Hello, welcome to my talk on an introduction to patenting computer implemented inventions from our series of talks on intellectual property. I'm Scott King, a European and UK patent attorney in the computer technology group here at GJE. GJE is a specialist IP law firm and I'm based in London. So in the last part of the talk, we discussed the exclusions from patentability and details of the approach that the European Patent Office takes toward computer implemented inventions that we need to provide a technical effect. So I'm now going to run through a few examples with you so we can discuss and we can see if these example computer implemented ideas are technical and non-technical and whether they would be patentable or not patentable in Europe. So the first example is a mobile phone, which includes a piece of software that's capable of modifying the power usage depending on the current signal strength. So when the phone is in a region with strong signal, so for instance, close to a base station, the power supplied to the transmitter of the phone is reduced as the connection is good. Whereas when the mobile phone is in a region with poor signal, so it's further from the base station, the power that's supplied to the transmitter is increased, so the signal is improved. So this means that the mobile device can save power when in high signal areas without being at the expense of signal quality. So is this technical or not? Well, this would be deemed to be a technical idea, as it's clearly solving a technical problem, it's conserving battery and providing improved signal strength in a technical way by changing the transmit power. So this is a technical innovation and would be likely to be patentable in Europe. The second example is an improved spell checker. So it's a piece of software that can accurately detect a misplaced comma in a text document. So is this idea technical or not? So this would be deemed to be a non-technical idea, as there's nothing technical being done here. It's just a piece of software for detecting a linguistic error. So this is not technical and therefore wouldn't be patentable in Europe. The next example is a new technique for supplying a shopping itinerary to a user. So the invention is that a shopper enters 2 or more desired goods into their mobile device before going shopping, and the software on the device displays a shopping itinerary showing an order or a sequence in which the shopper can visit a group of vendors in order to obtain the desired goods. So the itinerary is shown as a function of the user's profile. So the user might determine that they want the shortest distance between shops or goods at the cheapest purchase price. So this idea is deemed to be a non-technical idea, as the overall effect of producing an ordered list of shops is determined to be non-technical, so will be unlikely to be patentable in Europe. How about an image processing technique? So software that's capable of processing an image that a user is captured by a camera to remove noise from the image. So this is likely to be technical, as it's providing an improvement to the image by reducing the technical constraints of noise that's been imparted on the image. So it's solving a technical problem. However, a different type of image processing, such as Snapchat filters, is unlikely to be technical, as it's just an aesthetic thing that's been added to the image, and the image is only different in that it has an aesthetic addition to it. And the final example is resource allocation in an operating system, such as memory allocation to make the computer operate more quickly. So this would be deemed to be technical, as the computer itself is a technical thing, and making it work more efficiently is clearly a technical consideration. So we've just been looking at the European approach, which is to determine whether the invention is technical or not, and gone through some examples. However, the law that defines the exclusions and the list of exclusions and the as such clause are applicable to both European and also UK law. However, the way that each patent office implements this law is not quite the same. And the UK Patent Office use what's called the Aerotel approach, which has arisen from case law in the UK. However, despite the apparent difference, the outcome should, in theory, be the same. So the Aerotel approach includes these 4 steps. So first of all, properly construe the claim. So what's the invention that you're trying to protect? Secondly, identify the actual contribution. So what is the thing that's new over what is already known? Thirdly, ask whether this falls solely within excluded matter. And then fourthly, check whether the actual or alleged contribution is actually technical in nature. And this approach taken by the UK Patent Office asks a similar question at step 4 to what we were asking in Europe of whether the invention is technical in nature. And to aid the applicant in the UK, there's helpfully been further guidance, what's called the AT&T signposts. And these helpfully set out some questions that an applicant may ask themselves to determine if the invention is technical. So they are the first signpost, whether the claimed technical effect has a technical effect on a process carried on outside the computer. The second signpost, whether the claimed technical effect operates at the level of architecture of the computer. That is to say, whether the effect is produced irrespective of the data being processed or the application being run. The third signpost, whether the claimed technical effect results in the computer being made to operate in a new way. The fourth signpost, whether the program makes the computer a better computer in the sense of running more efficiently and effectively as a computer. And the fifth signpost, whether the perceived problem is overcome by the claimed invention as opposed to merely being circumvented. So if the answer to any of these signposts is yes, then it's likely that the invention is technical. So when considering patenting a computer implemented idea, I often find it useful to look at these signposts and consider them as if one of them is met, then we probably have a good chance of avoiding this exclusion. So let's go through the first 2 examples that we previously looked at and apply the AT&T signpost to see if we agree with our opinion that we previously came to, that the inventions are technical and non-technical. So firstly, let's look at the transmit power control in the cell phone example. So looking at the first signpost, whether the claimed technical effect has a technical effect on a process which is carried on outside of the computer. Well, I think the answer to this signpost is no, as the technical effect of the change of battery usage is on the computer device, the mobile device itself. So I don't think it passes the first signpost. How about signpost 2? Whether the claimed technical effect operates at the level of architecture of the computer, irrespective of the data being processed or applications being run. So I think the answer to this is yes in this case, as it doesn't matter what data has been processed by the mobile device, and the battery usage is changed nevertheless, which could be considered the architecture of the mobile device. So I think the answer to the second signpost is probably yes. How about the third signpost? Whether the claimed technical effect results in the computer being made to operate in a new way. So again, yes, again, the computer is operating in a new way by changing the battery usage. So it's changing the way that it operates. So the third signpost is also met. How about the fourth signpost of whether the program makes the computer a better computer in the sense of running more efficiently and effectively as a computer? Again, I think the answer to this is yes, as the computer is operating in a more efficient way by changing the battery power. And how about the fifth signpost of whether the perceived problem is overcome by the claimed invention as opposed to merely being circumvented? Well, I think the answer there again is yes, as the technical problem of poor battery life is improved by this invention. So we're agreed that the invention is technical as it meets at least the second, third, and fourth and fifth signposts. How about the second example, the improved spell checker? So looking at the first signpost, whether the claimed technical effect has a technical effect on a process carried on outside of the computer. Well, I think the answer to that is no, as the spell checker is definitely operating on the computer itself. How about the second signpost? whether the claimed technical effect operates at the level of architecture of the computer, irrespective of the data being processed or applications being run. So no, this is definitely based on the data being processed, as it's checking the spelling. So it fails the second signpost. How about the third signpost of whether the technical effect results in the computer being made to operate in a new way? So I think this signpost also isn't met, as the computer is still operating in the same way. It just has a spell checker on it. How about the fourth signpost of whether that makes it a better computer running more efficiently and effectively as a computer? Again, no, the computer is still running in the same way. And the fifth signpost of whether the perceived problem is overcome by the claimed invention as opposed to merely being circumvented. So I think the problem of incorrect spelling still exists. It's just circumvented by having a spell check. And this also isn't a technical problem. So again, we're agreed that the invention is non-technical, as none of the signposts met. So here are the list of the examples that we've just looked at, and a couple more examples of technical and non-technical innovations. So a couple more examples of technical innovations are automatic headlights in a car, so a piece of software that controls a headlight being turned on automatically, such as in low light. Cryptography and security of data transmission is also deemed to be technical. On the non-technical side, improve the graphical user interface is deemed to be non-technical. And calculating pension contributions is also not technical. It's a financial problem, which is an artificial man-made concept. So far I've touched on the UK and European approach for computer implemented inventions, but a major market for many companies in this area is the US. And that may be where another myth may have originated that people have heard, that patenting software is possible in the US, but not possible in Europe. And it's agreed for many years that the US has had a more liberal approach to the patenting of software. However, this has changed somewhat in recent years due to the series of Supreme Court decisions. And now the test in the US is that an abstract idea is not patent eligible, and a patent eligible idea must amount to significantly more than an abstract idea. So merely applying a business method with a computer doesn't confer patent eligibility. And from my experience, it's still generally easier to get a patent granted in the US than in Europe, but it is getting less so. So here's an updated list of examples, but taking the abstract test of the US. And it could be argued that the graphical user interface and the spell checker may pass the abstract hurdle in the US. So you might get a different outcome in the US for these inventions. However, largely, as you can see here, the outcome is generally the same between computer implemented inventions. So thank you for your time. In this talk, I've provided you with an overview of patenting computer implemented inventions and hopefully dispelled some of the myths that are out there. If you'd like to find out more, please watch some of our other talks in this series. Please find details of our website, or feel free to email me or add me on LinkedIn. Thank you.